All right, if you're gearing up for the Queensland bar, there's one piece of procedure you absolutely have to know inside and out: the Supervised Case List. This is the Supreme Court's playbook for handling its biggest, most complex cases, and it's all laid out in Practice Direction 11 of 2012. Trust me, this isn't your standard civil procedure. It's a whole different ballgame. So, let's dive in and break it down.
So what's the magic number? What's the main trigger that lands a case on the Supervised Case List, or SCL? It's right here. More than 5 days. If your trial is estimated to take longer than a working week, it's pretty much automatically getting referred. Now, a judge can always place any particularly complex case on the list, but that 5-day estimate, that's your big flashing signpost. And that really gets to the core of why the SCL even exists. Think about it. These huge cases, we're talking dozens of witnesses, mountains of documents, complex legal arguments, they can easily turn into procedural and financial nightmares. The SCL is the court's answer to that chaos. It's an intensive, judge-led management system designed to keep these massive pieces of litigation on track, on budget, and on time.
So here's our roadmap. We're going to look at why the SCL exists in the first place, then walk through how a case gets on the list. We'll cover the judge's review process, dive deep into document management, which is a huge one, then look at the final path to trial, and wrap up with your core responsibility as a lawyer in this system.
First up, why does the Supervised Case List even exist? If you don't get the philosophy behind it, the rules will never quite click.
Everything, and I mean everything, about the SCL flows from this one principle. It's the overriding purpose from Rule 5 of the Uniform Civil Procedure Rules. Every direction a judge gives, every rule in the practice direction, it's all aimed at one thing: finding a just, quick, and cheap way to solve the real disagreement. This isn't just a nice idea, it's the DNA of the whole system.
And paragraph 3 of the practice direction turns that philosophy into a concrete action plan. We're talking about zeroing in on the genuine issues, not wasting time and money proving things everyone already agrees on. It's about pushing the parties to talk settlement early and often. And crucially, it's about making sure a case is 100% ready for trial before a date is ever set to stop those costly last-minute adjournments.
Okay, Section 2. Let's get practical. How does a case actually find its way onto this list? What's the pathway?
It's a very clear, systematic process. That 5-day trigger we talked about, that leads to an automatic referral from the court registry. From there, the parties have to fill out a detailed questionnaire. This gives the SCL manager the info they need to assign a single supervising judge who will stick with the case from start to finish. Then, that judge's associate gets in touch to schedule the very first review hearing.
All right, Section 3, the judge's review. Think of this as the engine room of the SCL. This is where the active, hands-on case management really happens. Now, pay attention, because this is a huge point of practice, a rookie mistake you just can't afford to make. Paragraph 14 is crystal clear. You can't just send a junior lawyer along to a review to take notes. The person who shows up must have day-to-day conduct of the file, and, critically, they must have the authority from the client to make real, binding decisions right there in the courtroom. Show up without that, you're going to make a very, very poor first impression. So what actually happens in these reviews? Well, paragraph 16 basically gives you the agenda, a checklist. At every single review, the judge is going to be running through the state of the pleadings, what's happening with disclosure, whether you've considered mediation, expert evidence, trial plans, the works. You should use this list to prepare for every single review hearing you have. Okay, on to Section 4, document management. Now, this is probably the single biggest departure from standard court procedure, and it's something you absolutely have to master. The guiding light, the golden rule for everything to do with documents on the SCL is this principle: proportionality. And it's not some fuzzy, vague concept. It's a hard rule. Every single action you take, every document you ask for, has to be justified by weighing the complexity of the case and what's at stake against the real-world cost and benefit of that action. So let's compare. In a standard case, the rule is you have to disclose every document that is directly relevant. This can lead to these massive, expensive document dumps. The SCL flips that on its head. The duty to disclose is deferred. Instead, the parties have to agree on a document plan. The whole mindset shifts from disclosing everything to disclosing only what truly matters to solve the real issues. So how do you actually argue about what's proportionate? Guideline 7.1 gives you the toolkit. When you're negotiating that document plan with the other side, these are the factors you'll be debating. How complex is the case? How much money is involved? How many documents are we talking about?
How much will it cost to find them? And what impact will they actually have on the final result? This is your framework.
We're getting closer to the finish line. Section 5, the path to trial. Before you can even ask for a trial date, there's a final series of checks and balances.
And this is absolutely critical. This is not a list of polite suggestions. Under paragraph 32, before you can ask for that trial date, you, the lawyer, have to personally stand up and confirm to the judge that you have recently thought about every single one of these issues. It's the court's final safety check to make sure your case is lean, focused, and genuinely ready to be heard.
And that brings us to our final section, your core responsibility. Because being successful on the SCL is about more than just following the rules. It demands a completely different mindset.
Honestly, this one quote from the guidelines says it all. The court expects you to be practical, cooperative, and cost-effective. The old-school adversarial tactics of hiding the ball or running up costs have absolutely no place here. Your duty is to the efficient administration of justice, and that means working with the court and the other side to get to the right result.
And that really leaves us with a final, crucial thought. To succeed in big, modern litigation, to thrive in a system like the SCL, your role has to evolve. It's not enough to just be a brilliant legal mind. You also need to be a strategic planner, a cost-benefit analyst, an active manager. So as you prepare for the bar, the question you really need to ask yourself is this. Are you preparing to be just a lawyer, or are you preparing to be a project manager for justice?